I am live. How does it feel to be alive? It feels great. We're almost in a new year. I've been trying to figure out while we're waiting for people to get in here. Been trying to figure out whether or not Chili was actually filing electronically, but I believe he is because the court orders are being sent out through the electronic filing system. So not being mailed out to old Jose, even though Marquis Arbaugh tends to, but they always, in their proofs of service, say that Chili is a non-ECF filer, and they mail his out to his address. Anyway, we are going to start with, this is document 71. This is Chili's motion to strike defendant's motion to dismiss. So Chili filed an amended complaint, and the defendants came in with a motion to dismiss, as one would expect, considering his second amended complaint was just as shit as his first amended complaint. So he moves the court to strike defendant's motion to dismiss plaintiff's second amended complaint, or for summary judgment, the motion in ECF 66, in full as it raises arguments and alleged facts without proper verification. I don't know what he means by without proper verification. Additionally, defendants could have raised these arguments in their original response, but omitted them. Well, maybe, except for all the new arguments he raised. Those they couldn't have raised an argument against until he raised them. Yay! I hope I did have a fabulous Christmas, and I hope you also have a fabulous Christmas, or had one. Isn't the appropriate response to a motion to dismiss an opposition? Yes. The court isn't going to make as big of a deal out of the title of a motion. That's not the important thing. The important thing is what he actually argues in it. So to make it bigger, well, that's what she said. So he says, defendants have already filed an answer. Plaintiff's amended complaint has not substantially changed in legal arguments and facts, but rather the amended complaint clarified what apparently sounded like conclusions of law to this court, but which were not. You know, I find that it's always a winning argument to essentially tell the judge that they're a fucking idiot and they don't understand the difference between a legal conclusion and a fact. And the amount of hubris that he has, because Chili, very plainly does not understand the distinction between a conclusion and a fact. To say, if he says, the cops used excessive force on me, that is a conclusion, not a fact. If he says the cops punched me in the nutsack, that's a fact, not a conclusion. The difference is that there is a step going between what the cops actually physically did and what you say they did. There's a step in there. And that step is to analyze it and to come up with an ultimate conclusion about what they did. The man crossed the road. That's a fact. The man jaywalked. That's a legal conclusion. Is the lady who believes in parents here? I remember her. She was fun. She's probably chasing her. I don't know what she's doing. I had something really mean to say there, and it would be taken entirely wrong by this audience. So I'm just not going to say it. What's important is the substance of the motion. The substance. Yes, that is correct. Rodent last name. Did she make me? I haven't brushed my hair this morning. Is that what you're trying to say? Sorry. In the alternative, plaintiff respectfully, I just called you dumb, but now I'm going to respectfully move the court for an extension of time to file an opposition to the motion. Plaintiff needs another 30 days to respond to said motion, as he just yesterday received defendant's thumb drive containing multiple hours of video after they sent it to the wrong address because he is currently working on an appellate brief in his Ohio case that is due in 1 week. The holidays are getting in the way. He is a pro se party. Why is Chili referring to himself in the third person? Oh, that's because Chili isn't writing these, right? You know what? When she fails, sometimes you have to take things into your own hand. You know what I'm saying? You know what I'm saying? You know what I'm saying. I don't know why he tries to be all formal like this. I need another 30 days to respond to the motion, as I just yesterday received the thumb drive after they sent it to the wrong address, etc. Motion of points and authorities. Yes, the court can extend time, and the court likely will extend time. Grinder? Is that Grinder or Grinder? I don't know. I know there's an app called Grinder. That's where WTT picks up all his dates. But is that how it's spelled? Yeah. So he will get the extension of time. Now he says defendants don't get another bite at the apple. An amended complaint does not revive the right to file a post-answer motion to dismiss, with the exception that new claims may be attacked. Here, defendants file an answer, have participated in discovery, and have attacked more than just the new claims. Well, here's the thing. So normally if you don't file a motion to dismiss, if you file an answer without a motion to dismiss, you can't come back later if there's an amended complaint and file a motion to dismiss if the claim that you're trying to dismiss was a claim that you could have filed a motion to dismiss on originally. I don't know if that makes sense. So the first time a claim is presented, basically you have the option of filing an answer, or filing a motion to dismiss. If you file an answer, and it's mutually exclusive, basically. If you file an answer, then you can't file a motion to dismiss, right? And what people have tried to do in the past is they filed an answer, then the plaintiff amends the complaint to fix some technicality. And then the defendants are like, ooh, we should have filed a motion to dismiss the first time, so we're going to come back now and file a motion to dismiss because we get to file a motion to dismiss based on their amended completing, right? And the way the courts, it's not a universal rule, but the way that the courts tend to deal with this, and again, it's not universal, so a court doesn't have to do any of these things, is the court will tend to not allow that. They won't allow you to attack a claim that you could have attacked the first time but didn't. So what Chili is saying is that since they filed an answer, then they don't get to file a motion to dismiss. Well, there's a couple problems. The first problem is they only answered the allegations that involved excessive force. You're in the wrong stream, Sproutsy. Sorry, got a little distracted there. So they answered only they filed a motion to dismiss all of the other things, and they only answered about the excessive force claims and the things that were that would align with the excessive force, like the state assault and battery charges and things like that. So those are the only ones that they answered. Now, he came back and he filed everything over again, including the things that he lost on, because obviously the judge just got it wrong. And in addition to that, he amended portions. He pled new things into his allegations that would cumulatively come under the umbrella of excessive force. So in that instance, it is appropriate to allow the defense to make a motion to dismiss on all of the causes of action that had previously been dismissed with prejudice. It's proper for them to do that because they have a new reason to file a motion to dismiss on them that they did not have available to them previously. They were dismissed with prejudice. He's attempting to replead them. It is perfectly appropriate for the defense to file a motion to dismiss based on res judicata. The other ones are perfectly acceptable to be attacked based on summary judgment. Now, the way that is going to work, well, either by well, it'd be appropriate by summary judgment. He actually does technically have a point, because what the officers are doing and the police department are doing is they're also now saying that these videos, the officers' videos, show that there was no excessive force, and they're alleging that these are integrated into the complaint because Decastro mentions them in the complaint. Now, as that would be concerned, they had this evidence at the time. They could have and should have made the argument when they initially filed their first motion to dismiss. Instead of filing an answer to the excessive force claims, they should have filed in their motion to dismiss these particular police camera recordings, made their argument that it was integrated into the complaint because of what Decastro said, and argued then for their dismissal, and or if they weren't integrated by the complaint, then a motion for summary judgment based on them. But because they've asked for summary judgment in the alternative, I think it's probably okay for the court to have allowed this to proceed, even though they have filed an answer as to those issues. So then he goes on to say, inauthentic evidence attached. Since defendants offer evidence attached to a summary judgment motion, it must be admissible to be submitted. Is that actually the case? Let's see. What are we doing? FRCP 56? What was it? FRCP 56. All right, and he's saying 56C. Or other materials, okay. Showing that the material cited do not establish the absence of or then party may object that the material cited to support or dispute a fact cannot be presented in a form that would be admissible as evidence. Okay, that's something that I was not specifically aware of. Well, let's see why he's going to say that it could not, that the video recordings by the police, their body cam videos, let's see why he says they could not be admissible. He then goes on to say it can be inferred that the affiants are not competent to testify to the video being unedited or to its chain of custody, not being an expert or the defendant's records custodian. Well, here's the fun thing. He sued the Las Vegas Metropolitan Police Department. The custodian of the records for those body cam videos would be the Las Vegas Metropolitan Police Department. The entity, sounds like SMT is hitting the microphone. No, I will try not to touch the table, Tom. The table, Tom. Because the entity, Las Vegas Metropolitan Police Department, is a defendant, somebody at the Las Vegas Metropolitan Police Department would be the custodian of records for it. So I don't know why he's making that, why he's making the inference that there is no records custodian there. I don't know why. I don't know why he's saying. I don't even know what he would bother. Or he would gain by that. And individually, the amen. WTT. Amen. Individually, each officer would be able to testify. This was my body cam video, and there are no edits to it. This is where I started it and stopped it. You can see this is where I started. This is where I stopped it. This is a true and correct copy. Each defendant would be able to testify as to their own body cam video, even if there was no custodian of records for LVMPD. Affiants do not testify to who produced the documents. They don't have to, and only provide conclusory statements as to their competency, and fail to properly support that assertion. Yeah, it is literally just saying. The custodian of records, all they have to say is basically, I'm the custodian of records. These are true and correct copies of the records that we have in our possession. And that's it. Like, it's very conclusory. That's you don't need anything more. I don't know what he's expecting that they would need more. He says it is more likely that these records were produced by a vendor or records custodian who refuses to testify under oath. Well, I don't think so, because again, each defendant could testify as to the truth or lack thereof, the accuracy of the. You really got your head effed up, boy. Got sliced up pretty good. Kenzie got in a fight with Siobhan a couple days ago. He has a couple cuts on his head that are all crusty now. She's mean to him. He's an old dog, and she's bigger than he is, and she's mean to him. The videos the defendants made available under Public Records Act requests were incomplete. Well, yes, because those were made available under Public Records Act, so those can be redacted. And are indicative of a credibility problem that calls the completeness of these videos into question. Well, the Public Records Act ones would be different than what they would produce for the court. Like they're gonna blur out personal details and things like that. The face of other people who aren't involved for the Public Records Act stuff that they wouldn't do for the court copy. And are indicative of a credibility problem that calls the completeness of these videos into question. See, Chili runs into a problem when he throws out things like this. He's not actually saying anything. He's saying that there could be an issue, not that there is an issue. And what he needs to say is, this particular video shows an edit at this spot, it's incomplete, etc. Right? And he needs to be able to support that. The Public Records Act video shows an additional 3 minutes of video after this point. The video provided to the court does not provide that extra footage, and so this has been edited. You need to actually plead something. You can't just you can't just throw something out there like, well, this could be, this may be. It can be inferred. You can't do that. The court doesn't go based on inferences. The court goes based on facts, on what you can show the court. Then it goes on. It is possible. Again, that's not. So what he's saying is he doesn't fucking know. It is possible. It's possible that it's going to snow here tomorrow. It's possible. It's not probable, and I have no evidence to support my assertion that it's possible that it might snow here. But it's possible. Possible, sure. It's possible that what is available in defendant's exhibits contains incidents in this action, but it is unlikely they are unedited or show anything relevant to or contradictive of plaintiff's testimony, nor is it the best evidence. The best evidence rule is like submitting the actual copy of a deed into evidence instead of someone's testimony about what the deed says. So I don't know what he's trying to say here. The video, the court is going to place a lot of weight on the video, and unless Chile can show that there's a problem with it, then the court is not going to be convinced by this at all. Plaintiff's own recording of the incident, which is the only video reference in the Second Amended complaint, is the best evidence, and defendants have not submitted it. Well, they don't have to submit it. If Chile referenced his own recording of the incident in his Second Amended complaint, then Chile can attach it to his opposition and say, this shows me getting punched in the nuts. This shows my ulnar nerve getting pinched, or whatever the complaint was. The defendants don't have to submit not exculpatory evidence, evidence that would harm their side. The defendants will produce, even at trial, the defendants will produce only the evidence that they believe will help them. They won't produce any evidence that they don't believe will help them. And they don't have to. That's what discovery is for. That's the only time. They can give Chile all of the evidence that they have, and then Chile can do with it. But even with this said, like why does Chile think that they have plaintiff's recording of the video? Why do they think they have it? Like the original copy of that is going to be on Chile's phone that he was recording with. So, and Chile has his phone, right? So it would stand to reason that Chile should produce that. And again, all Chile would have to say is I'm the one who recorded this video, and it's a true and correct copy of the video I recorded, and it's unedited. Boom. All conclusory statements. That's all he has to do. And the defendants won't say shit about, oh, it's not properly authenticated or whatever. And does Chile's recording show any? Yes, that was his yeah. Here, defendants, quote, evidence, end quote, is neither the best evidence nor is it properly authenticated and should be stricken. You fucking fail on that argument. Evidence submitted outside the four corners of the complaint. Well, luckily for them, if it was just a motion to dismiss, it has to be based on things in the complaint. But they also styled it as a motion for summary judgment, which the court can look at evidence outside of the complaint. So I don't know why we're going to do this, but I guess we're going to do it. Since the defendants offer evidence attached to a motion to dismiss, it should be disregarded as improper and should be stricken. But again, it was a motion to dismiss if the court found that the body cam footage was incorporated into the complaint. Otherwise, it was a motion for summary judgment. Just because plaintiff mentions that body cam footage may offer evidence of further illegal behavior by defendants doesn't make all body cam footage in defendant's possession referenced in the complaint. Well, no, but see, that's a disingenuous argument. And I have a real problem with people who make this kind of disingenuous argument. Plaintiff mentions that body camera footage may offer evidence of further illegal behavior. So he's mentioning body cam footage. So the relevant body cam footage would be body cam footage showing the interaction between the officers and Chili. Not all body cam footage, not of their interaction with someone besides Chili, but of their interaction with Chili. On that date, at that time, what does their body cam footage show? Further, plaintiff disputes the authenticity of the videos. Well, like that's a fucking nothing. That bleh. Go piss up a rope. I dispute the authenticity of the video. Even where plaintiff referenced these videos and the authenticity was not in dispute, this court would still have the discretion and would not be required to incorporate the videos. Yes, the court has the discretion. Conversion to a motion for summary judgment. Since the motion is not clear on where the motion for dismissal is separated from the motion for summary judgment, it's pled in the alternative. Plaintiff will look to this court to give its express notice of its intent to convert the motion from a 12b6 motion, even though defendants have already filed an answer. The court to give its express notice of its intent to convert the motion. Well, Shelley, I had to break this to you, buddy. They asked for summary judgment in the alternative. It all goes to whether or not the court thinks that those particular videos were incorporated into the complaint by reference. So what you should do, Chili, is you should fucking throw all of your fucking spaghetti at the wall and hope that something sticks. Whether or not it was in the complaint, anything that you have, Chili, that you think shows that these officers did anything wrong, you need to fucking include it. It should have been in your complaint in the first place, which you're retarded and you don't know how to do. It should have been there in the first place. But if it wasn't, you need to treat this as a motion for summary judgment. You need to throw all the spaghetti you got, and none of it's going to stick. I don't see why he wouldn't. I don't think they have any sort of an agreement that he has to keep them private. I assume so. 12b6 motion is improper where parties filed an answer. A motion making a 12b6 defense shall be made before pleading if a further pleading is permitted. They filed an answer, so the motion should be stricken as improper. Well, again, as to the claims that you realleged that were dismissed with prejudice, it is proper for them to file 12b6 on those claims. The 12b6 is to dismiss a claim. So that's perfectly fine. Again, there might be some issue that they've already answered the excessive force issues, but whatever. Motion to strike appropriate. The court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. All right, well, is a motion not a pleading? A pleading technically, a pleading is the complaint. It's the answer. That's a pleading. A motion is different than a pleading. It's like, you plead guilty. The state is pleading to the court in their complaint that these are the things you did wrong. That's a pleading. People are fucking stupid. People are fucking stupid. All right, moving on. Motion to compel discovery responses. So, Chili files a motion to compel. He's made a good faith effort to meet and confer. But has he? The discovery sought by plaintiff is relevant to plaintiff's claims or defenses. Why does plaintiff has to have defenses? That's fucking weird, isn't it? Isn't it fucking weird that a plaintiff would have defenses? There's no cross complaint. Why would it be relevant to plaintiff's claims or defenses? What defenses do you have, Chili? The discovery sought is proportional to the needs of the case. I doubt that, especially considering the importance of the issues at stake in the action. The importance of the issues at stake in the action. Oh my! The amount in controversy, which, as far as I can tell, is fucking nothing. I think he went to a dock in the box for $150. So let's say he got that. Let's say they gave him pain and suffering at 3 times that. So that would get him up to around $600. The constitutional restriction on punitive damage is somewhere around 10 times. That's the cap, somewhere around 10 times. We know 8 times is good. We think about 10 times is probably where the constitutional cap is. So that's about $6,000. So $6,600 in theory he could get if he prevailed. That's what I can see. And it's things like this, which are why most of these cases settle. Like, you could get more than $6,600 settling a case like this, because the defense is likely going to pay way more than that just to do all the discovery and everything like that. Now, one real problem is, like, Chile probably could have. There were a couple times in here where Chile probably could have settled this, like right after the motion, the initial motion to dismiss was decided. That would have been an opportunity. Chile says, "Ha, I'm still in the game, right? Let's settle this." You talk to the defense attorney. You don't want to. Your client doesn't want to spend more money on this, and I've already shown that I can survive, and so we could waste a bunch of money going to trial on these issues that I've survived on, right? Sorry, my dog is Kenzie is in the cord, moving the mic around. But that would be the time. That'd be the time to settle, because there is no pending motion to dismiss. Now that they've got a pending motion to dismiss, they're not likely to settle it, because they've already spent the money. Let's wait and see what the court says. And then after that, then if you still survive, then maybe they'll talk settlement again. But it's not. Have I heard of it being, or I've never seen it being ordered for cases like this. It's always available. So yeah, he had a good time to settle it. There is not a lot in controversy here. I'm kind of surprised. That the defense hasn't tried to kick this back down to state court, because of the. Oh no, there's a 12 or 42 USC 1983. So there's a federal question, so we can't kick it down to state court. My bad. Discovery is sought as proportional to the needs of the case, especially considering the importance of the issues at stake, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. See, he talks about other people making conclusory statements, and then he just goes and makes a whole bunch of conclusory statements. What the fuck is wrong with Eugene fake government audits? You cowards. What the fuck is wrong with these people? What is wrong with these people? Defendants have not objected to any of plaintiff's discovery requests, and the time limit to do so has expired. Plaintiff sent the attached request for production of documents, but has not received any responses. Plaintiff requests this court to order defendants to compel discovery for plaintiff's first request for production of documents. Plaintiff requests this court compel discovery or compel defendants to produce the discovery requested. I don't know. Order defendants to compel discovery? That's kind of weird. Certification of meet and confer requirements. I attempted to meet and confer. See, that's not a fact. That is a conclusion. I attempted to meet and confer and discuss the proposed extension of time to respond, but defendant's counsel has been generally unavailable when I call his office, or when I get him on his cell phone, he says he sent it and changes the subject and otherwise fails to respond. Prior to the response due date, Anderson did confirm receiving the request for production and even confirmed the due date of December 16th in 2 separate emails. I called defense counsel at the following times on 12/18, 2:06 p.m. What he should say there is what happened. What was the outcome of it? Left a message. Talked to Anderson. He says he sent it and hung up on me. And then he says again, he called the cell phone on this date. He called the office. He called the office. He called the cell phone. He called the office. I've even texted Anderson back and forth. What were those texts? What did they say? On this date at this time, I texted him this. He didn't respond. On this date at this time, I texted him this. He didn't respond. When I repeat to him that I've not received the discovery and ask if he wants to agree to a new due date, he just says he already sent it and sends me another copy of defendant's initial disclosures. Show us those conversations. I've now received initial disclosures 10 times and keep telling him it's not what I'm referring to. He seems to be playing games. Well, if you have received them 10 times, if he's 10 times he sent those things to you, you should show it. Attachment 1. So this is his joke of a request for production of document. Set number first. Set number 1. All right. So the responding party. So not responding parties, plural. This is supposed to be which party. There are 1, 2, 3, 4, 5, 6, 7. 7 parties listed there. Which party is supposed to be responding to these? You ask a specific party to produce the documents. He should have sent out 8 separate requests for production. And that way he would know what he was getting back from each defendant. But is just generally speaking, it's a specific party. You can't just ask every defendant the same thing, even though they're all represented by the same counsel. Instruction: electronically stored information shall be produced in the following format: searchable PDF, including timestamps for messages. Well, I hope he's not asking for video or audio, because if that's electronically stored information, which it is, in order to comply with this, they would have to produce a PDF of it. You dumb fuck. If defendant objects to the production of any document on the grounds of attorney-client privilege or work product doctrine or other privilege or doctrine, defendant shall provide the unprivileged portions, and on the date responses are due, provide a privilege log that includes the following information for each document: the names of each writer, sender, or initiator of each copy of the document, the names of each witness, address, receiver party to whom the document was sent or who received the document, the date of each copy of the document or an estimate of its date, a non-privileged description of the contents of the document, the relevant privilege or doctrine, and a statement of the basis for the claim. He's more or less entitled to that. Generally speaking, you would produce a privilege log. It would state, and since it would be per party, you'd have to ask each party this. It would say whether the party sent it or received it, who it was sent to or received from, a generalized description of what it was, and the reason for the privilege. So October 14th at 10:53 a.m., defendant Bob sent his attorney an email generally regarding this case. It's not hard to do, but a privilege log is mandatory. It is mandatory. This is Federal Rule of Civil Procedure 26, and it is like B5. When a party withholds information otherwise discoverable by claiming the information is privileged or subject to protection, the party must expressly make the claim. They must describe the nature of the documents, communications, or tangible things not produced or disclosed, and do so in a manner that, without revealing information itself privileged or protected, will enable the other parties to assess the claim. So they were required essentially to produce a lot of that information, but they would not have to do all of this in this format. This is just, all of these instructions are just a wish list. And I love this. The definition of document and the definition of communications are redundant. All communications are documents. So if he asks for a document, that would include communications. So pretty stupid. So Article 3 is the request. Request for production number 1. All communications between any defendant and any other defendant. So, oh boy, the guinea fowl have come to visit, by the way. You should go chase them, Kenzie. You should go chase those guinea fowl. This is not restricted to time. This is something that you would definitely object to, because like if one of these officers has been working for the Las Vegas Metropolitan Police Department for the last 20 years, there's 20 years of communications that they would theoretically have to provide as stated. And plaintiff will be adding claims for conspiracy to the amended complaint. Like, it's not relevant until you've actually amended the complaint to add conspiracy claims. Request for production number 2, all communications between you and any person associated with the Las Vegas Police Protective Association. So I wouldn't know what a person associated with the Las Vegas Police Protective Association was, but basically what this is looking for is every communicate. So if all of the officers are members of the Las Vegas Police Protective Association, and well, their wives would be associated with them through their husbands, or their husbands would be associated to it through their wives. You know what I'm saying? Like, how would you, like, this is so overbroad, burdensome, vague as to time. Just terrible. All communications concerning plaintiff or his associate or his associates, including Floyd Wallace, between you and any other person, including but not limited to family members and colleagues. What the fuck is an associate? What are plaintiffs? What are Chili? Name me 2 of Chili's associates, or 3. Like, I mean, apparently Floyd Wallace is one. What's the defining characteristic there? I don't know. And what does concerning mean? Request for production 4. All documents and things that would show any current or past organizational structure between each defendant. What the fuck does that even mean? LVMPD employs the defendants. That'd be the organization, but all documents and things that would identify the true name, address, and phone number of each defendant. Good fucking luck. Request for production number 6. All documents and things concerning the disparagement of plaintiff and his associates. First of all, what does that mean? And second, not just from one of these defendants, but what are they supposed to do? Go out on the internet and find all the videos that I made talking shit about Chili's ability to prepare legal pleadings and other motions and things like that? Number 7, all documents and things concerning the location, tracking of location of plaintiff or his associates. Again, who the fuck are his associates? And why does he think that they're locating him or tracking him? Number 8, all documents and things concerning the facts or reputation of plaintiff or his trade. Why would they have documents concerning the facts of, the facts of plaintiff, the reputation of plaintiff, the facts of plaintiff's trade, or the reputation of plaintiff's trade? That is fucking stupid. Oh, Jesus Christ. These are hard to read. 9, all documents and things concerning harassment, trolling, vandalism, hacking, or social media post, or any other behavior concerning plaintiff or his trade. All documents concerning social media post concerning plaintiff or his trade. What is Chili's trade? If Chili says that he is a journalist, and let's assume he is, then the LVMPD would have to produce every social media post they've ever made about journalists. If he's a protester, would they have to produce every social media post ever about protesters? Chili doesn't know what he's asking for. So one of the big mistakes that bad attorneys make and pro pers make is they try to ask for everything. They don't try to ask for specifically identifiable, narrowly tailored kinds of things. And because of that, they end up writing garbage that is not going to get them anything. Number 10, copy of any and all recorded interviews and respective transcripts conducted in connection with this action. Well, the recorded interview would have to be produced in a PDF format. How the fuck is that going to work? I mean, the transcripts would be producible in PDF, but yeah, recorded interviews. Who the fuck would they interview? It was some like shitty interfering with a police officer in the what did they get him for? Obstruction, something like that. I mean, recorded interviews. Like they have the fucking FBI field office out there and shit. Number 11, the name, address, phone number, and email address of any witnesses that each defendant intends to call at trial. Well, considering that the only real witnesses, the gal left before any of the gal at the stop left before any of the incidences, the alleged abuse. She left before Chili was arrested, so I don't know that they would call her. She would not be a good witness. So it's just going to be the cops and Chili, right? Number 12, the name, address, and phone number of all witnesses of the arrest and concerning incidents to the arrest in this action, including but not limited to officers and supervisors at the scene, dispatchers, and the passengers of the silver Hyundai Elantra that Bork was interacting with on March 15th, 2023, related to this action. He's asking for the name, address, and phone number of someone who was not a witness. Like the dispatchers aren't witnesses. They weren't there. They didn't see anything. So asking for the officers and supervisors at the scene, he has already asked for that. The dispatchers aren't witnesses. And the passengers, not the driver, the passengers of the silver Hyundai Elantra that Bork was interacting with. It's fucking weird. The passengers. Just like, holy shit, dude. Holy shit. Did you bother to read these before you sent them out? Number 13, a copy of any and all crime scene analysis and or forensic reports. Forensic reports. Fucking forensic reports. Forensic report for what? He had gunshot residue up his ass. Results. Requests for examination and or testing performed on any of the physical or biological evidence. What did he piss himself? Did they collect a sample of his piss when he pissed himself? What biological evidence, bro? What physical or biological evidence? They don't need physical. They have a cop who said, yeah, I was there. He fucking resisted, or he obstructed my, he obstructed me when I was trying to deal with another person. Like, that's it. Like, that's enough for conviction. They don't need DNA. Did they take Chili? Did they fucking take a blood sample from you, Chili? Did they do a blood draw on you, Chili? If they didn't do a blood draw, what the fuck are you asking for? Jesus Christ. Shoe prints. Got fucking Columbo over here taking shoe prints. Jesus. Fucking taking shoe prints. Back in the 1940s or some shit. This is for a minor misdemeanor, bro. They're not gonna. They don't need this. A copy of any and all audio recordings, which have to be produced in PDF format. Remember, and related documentation, including but not limited to 911 calls, CAD to CAD. I don't know what that means. Dispatch calls, communication logs, and any otherwise memorialized communications concerning this action, including but not limited to any communications where officers discuss, quote, First Amendment auditors, end quote, quote, the recording of police, end quote, this action, this actions, I'm fucking lost. Incidents leading up to this action and after the alleged incident concerning this action, the plaintiff or his associates. Who the fuck knows what he's asking for? Objection vague. I don't know what the fuck you want, bro. I don't even know what you want. Copy of any and all photographs taken or gathered, crime scene diagrams drafted, and investigative reports prepared by law enforcement in connection with this action, including but not limited to property inventory reports, impound reports, and images of the scene concerning any alleged incident concerning this action. 16. Disclosures of any and all details of any compensation express or implies, I think you meant implied, promises of favorable treatment or leniency or any other benefit that any of the state's witnesses, the state isn't a party to this case. He's suing LVMPD. Did he sue? No, he sued the state of Nevada, but the state of Nevada defaulted, right? Yeah, entry of default. So I guess the state is a party to this, but the state or Nevada defaulted. They're not doing discovery. So I don't know, man. I don't think the state is going to be putting on witnesses in this particular case. I mean, they'll probably put on witnesses in the criminal matter, but I don't think they're going to. with the prosecution. No, you gotta ask for that from your attorney. Your criminal defense attorney is the one who'd be asking for that kind of stuff, and that would be in your criminal case. 17, a copy of any and all written statements, reports, and or information provided by the alleged victims. By the alleged victims. Did Chili give a statement? And who's the other victim? Is this Chili talking about himself in the third person again? 18, a copy of any and all video and or audio recordings of the alleged incident and or otherwise related to the allegations in this case, including but not limited to body camera video recordings, including but not limited to any communications where officers discuss First Amendment orders, recording of police, this action, incidents including and leading up to this action and after the alleged incident concerning this action, the plaintiff or his associates. And by the way, produce it in PDF format. PDF format. Well, we know he got the body camera video recordings. He got those on, what was it, a week ago? Just yesterday. So he filed this on the 22nd, so he received the body cam footage containing multiple hours of video. He got that on the 21st, apparently. But they should have put it into PDF format for him. 19, complete criminal histories of all state witnesses. Again, the state isn't going to be putting forward any witnesses. And somehow I doubt any of the cops will have criminal histories. So I'm going to guess they're not going to get anything on that. Any and all information bearing on the truthfulness or bad character of the state witnesses. What is he talking about? Including but not limited to any contempt citations issued against the witnesses, any past instances of dishonesty, fraud, lying, or violence on the part of the witnesses that is known to the state or its agents. He's gonna need to get that information from his defense attorney. His defense attorney is gonna have to ask for that. Any and all documents made by any state witness or any other person that are in any manner inconsistent with the written and or recorded statements previously provided to the plaintiff. Again, what state witness? Request for production number 22. Any documents, including but not limited to copies of any and all copies of emails, text messages, memorandums, including any law enforcement office involving any law enforcement officer or other state personnel in which the plaintiff is mentioned by name or reference. These are, remember, he's limited to the production that the defendants, the individually named defendant, he's not supposed to have all defendants on one, but like if you directed this to the LVMPD, then they would have to go through all of their documents. But again, Vegas to time, it's not limited. There's like they're gonna have to go through all of their materials forever. I don't think that a court would make them do that. Number 23, any and all personnel discipline documents for any law enforcement officer or other state personnel involved in this action, including any past or prior discipline or reprimand for said officer's actions which were alleged or found to have violated the civil rights or liberties of other individuals. I'm not entirely sure, as phrased, he would be entitled to that. But that would be definitely isn't entitled to that in this particular case, but in his criminal case, I don't know that he would be entitled to all of that. I don't know about Nevada state law, but I don't think that they're going to give up discipline or remand for violating civil rights or liberties of other individuals. I don't think they're going to do that. California has a rule where you can get a lot of information from a officer's disciplinary file, but I don't know that Nevada has that. 24, any materials written or otherwise recorded relating to training any officers involved in the underlying case have received training said officers about the First Amendment, the right of citizens to film officers, and the relation between the First Amendment and obstruction of an officer's duties, including any policy manuals provided to any officer in this case which addresses those issues. Reasonable. 25, a list of any remedial or other training concerning the incidents of this case. Concerning? I don't know what that means. As well as the contents of that training provided to the officers involved in this case or the rest of the department concerning or as a result of this case, or where the contents of the training is related to the type of incident in this case. '26. Any of the department's use of force, arrest, misdemeanor arrest, and interactions with public policies, including any policies on dealing with the media, press, freedom of speech, and recording the police. Including any memos related to any of this that were in effect during the time of the arrest or that were enacted or distributed after. So use of force, arrest, misdemeanor arrest, interactions with the public policies, interactions with the public policies. So use of force policies, arrest policies, misdemeanor arrest policies, interactions with the public policies, including any, I'm going to guess that's policies, on dealing with the media. So he's also looking for policies on dealing with the media, dealing with the press, dealing with freedom of speech, and dealing with recording police. It'd be super swell if he would actually take the time to make these reasonable requests, make these into reasonable requests. Any document, photograph, or other paper the party intends to introduce a trial, well, they have to produce that anyway. Why are you asking for it? That's part of their initial disclosures. Request for production number 20, any exculpatory evidence that could help plaintiff what? Exculpatory evidence would be evidence that would tend to indicate that the plaintiff was not guilty. But this isn't a criminal matter. He's the plaintiff in a civil matter. What the fuck are you talking about exculpatory evidence? Request for production number 29, all non-privileged documents and things concerning this action. Well, that's a big fucking catch-all. What the fuck? See, he just doesn't know what to ask for at this point. So he's just asking for fucking everything. If you really want to be a dick, when people do shit like this specifically, you just have your client go get banker boxes full of business records from the last 40 years. Bring them out. Just fucking dump off 3 tons of business records. Enjoy. These are not privileged. They concern the action. Sure. They don't mention anything about me. Yeah, but it concerns me and I'm a part of the action, so it concerns the action. Shouldn't you have a better definition for concerning? I think you should. I think you should be concerned at how poorly you have phrased all of your requests for production. Number 30, all non-privileged documents the defendant sent to or received from any person concerning this action. That any defendant, I'm assuming, wouldn't that see number 29? Number 31, all non-privileged communications concerning plaintiff or this action. See number 29. Number 32, all documents concerning body-worn camera video, audio recordings, dash cam video, interview recordings, internal security audio and video, external security audio and video that include each defendant for the entire date of March 15th, 2023. I don't think they're going to get that. So if body-worn camera video specifically is going to have a lot of information on it, like when they're dealing with like their computer, if they have their camera on because they're in the middle of a stop or something, it's going to have all sorts of protected information up on their computer screen in their cruiser. When they're dealing with people, they're making confidential statements. He's not entitled to any of that. That is not related specifically to him. And number 33, all documents related to insurance policies that may cover liability concerning this action, or that was expected to cover liability concerning this action. You don't always have, is it state that you don't get to do discovery on that? Or it's limited, I guess. It's limited. You can find out if they are covered. But that's about it. You can find out who their insurance carrier is, but that's about it. You're not entitled to all documents related to insurance policies. I mean, that's just way overbroad. And that's it. Thank God. All right. And then this is their opposition to the motion to compel discovery. 26 pages. You gotta be effing kidding me. The motion to compel is misleading and waste of judicial resources. In the motion, plaintiff claims defendant she saw his old address on this shit. So Chili's e-filing. I'm 99.9% sure he's e-filing. And that's why I think that he hasn't had any issue by not putting a proof of service on these pleadings. Normally you would have proof of service. I wouldn't not put a proof of service on any pleading or motion or opposition. You just do it. And you do it because it's proof of service. And courts put a lot of weight behind that. But what I notice is that this document here, plaintiff's first request for production of documents, this would not be filed. Now he has filed this as an attachment to a motion, but this is normally not filed. You normally don't file discovery documents. And what I notice that there is not on here is there is not a proof of service. Now, this up here, the motion would be filed through e-filing, and so it would automatically be served on the defendants. But this one is not automatically served on the defendants because it's not e-filed and there's no proof of service. So he has a real problem just from the get about saying when it was served, how it was served, where it was served, why it was served, yada, yada. And I guess we'll find out about that. In truth, defendants timely mailed their responses to plaintiff's address. And when plaintiff contacted defense counsel claiming he had yet to receive the discovery, defense counsel, while on the phone with plaintiff, emailed in the responses with a Dropbox link. Thus, the discovery responses have been both mailed and emailed to plaintiff. Statement of subject incident, blah, blah, blah. Procedural history. Oop, I got an address on there. Hold on a second. Ah. All right. Can't show addresses. On November 16th, plaintiff improperly served the defendants with his first request for production of documents. On December 18th, defendants properly served their responses to plaintiff's first request for production of documents. Yeah, so they didn't have a discovery plan until November 20th. That's when they had the discovery plan. And when did the court sign off on it? So the court signed off on it on the 20th. So discovery was improper prior to the 20th. So Chile already fucked up there. But they're admitting they're giving it to him that he actually sent it to them on the 16th. So even though he didn't have, oh, you're not seeing this. Shit. There you go. So the stipulated discovery plan and scheduling order was filed on November 20th. So, so them giving him that he actually served it is like a kind of a gimme, because they could have said he never served it, he doesn't have a approved service, but they're being honest, so that's great. So on December 18th, defendants properly served their responses to plaintiff's first request for production. Concurrent, they also served their first supplement disclosure of witnesses and documents. Both of them were mailed to an address. Damn it. I'm terrible with the scroll wheel on this one. I want one line up, just one line up. On December 15th, plaintiff identified this address in his notice of change of address with the court. The defendants provided plaintiff a Dropbox link for documents and videos referenced in their discovery responses. The Dropbox link remains valid through January 18th, 2024. So if anybody wants to go to the Dropbox link, woo! It might be one of those ones where you have to have like the right email address to get into it. On December 21st, plaintiff called defense counsel requesting the status of written discovery responses. Defense counsel informed plaintiff that the responses and the supplement had been timely mailed to his preferred address. Plaintiff claimed that he was having difficulty receiving his mail due to a, quote, roommate issue. Raro. I guess, who's that guy who liked to be the top for Chile? That Chile expressed so much love for? David something or the other? Oh, Paul, you tried. It's no longer valid. Poop. David Condon. That's correct. Tomatoes or tomatoes. So I guess David wasn't pleased with the amount of productivity his bottom was putting out for him. Get it? His bottom was putting out. Get it? You get it? Wink. In response, defense counsel, while still on the phone with plaintiff, created a new Dropbox link and immediately emailed the plaintiff's email address. Plaintiff now claims that this link was defendant's initial disclosures and that defense counsel, quote, seems to be playing games. Defense counsel has verified that the December 21, 2023 link was, in fact, the documents responsive to plaintiff's request for production. Legal standard. Plaintiff alleges he's entitled to sanctions. Did he ask for sanctions? I don't remember him asking for sanctions. Did he ask for sanctions? I don't see him asking for sanctions. He asked for the court to compel the production. He didn't ask for sanctions. Anderson, you suck as an attorney, sir. What? Did he even raise FRCP 37? Oops, that's 36, 37. Pursuant to compel. That's in. We're down. So there's only 2 spots he mentioned. He does not. (37) concerns things other than motion for an order, move for an order compelling, right? To compel discovery, right? So he's pro per. So there he has no. He hasn't. He couldn't ask for. I don't know why are we talking about sanctions, bro? Properly responded. The documents were timely disclosed in proper form, and yada yada. It appears he does know how to. It appears plaintiff does not know how to properly interpret the defendant's discovery responses and their first supplement to disclosure statement. An alternative explanation is plaintiff is intentionally misleading this court because he failed to timely file an opposition to defendant's motion to dismiss. Regardless, defendant's motion to compel must be denied. Based on the above, yada yada. So see how shit. You see how they have a certificate of service and they mailed it to an address that I'm not showing? That's what you need. And here is their, hold on, let me see if they have a certificate of service down at the bottom. This, yes, they have certificate of service. So they have lots of certificates of service that I can see scrolling past them. What I did not see scrolling down is a privilege log. I didn't think they would produce one. Attorneys never like to produce privilege logs. The documents are providing, radio calls. I don't see a privilege log. They never produce privilege logs. So they have objections. All communications is vague and ambiguous and overbroad. Well, it's overbroad. Is it vague and ambiguous? No, because he defined it. He defined it. It's not vague. He defined it. It's in all caps. It's a defined term. Why would you object to it as being vague and ambiguous? It's a defined term. That term, the specific term that he says is vague and ambiguous, has a fucking definition provided by plaintiff. Oh, you suck. Notwithstanding this objection, each individual defendant has searched all. Why didn't you object to the improper request that all plaintiff or that all defendants answer that one? You should have served like 8 different ones. They've searched all paper files of their unit, their computer, and their work cell phones and found no unprivileged documents responsive to this request. Any responsive emails are covered by the attorney-client privilege. You need to produce a privilege log on that. And what if they were keeping these in places other than their unit, their computer, and their work cell phones? He didn't limit it to unit, computer, and work cell phones. If they have it on their private cell phones, they need to produce it. All communications between you and any person associated with the LVPPA. And again, wow, stupid objections. That's a stupid objection. Notwithstanding the objection, each individual defendant has searched again, but it's not. You don't get to limit where you search, homie. Is it in your like? So technically speaking, like a bank statement, right? Or they wouldn't necessarily be entitled to a bank statement. Let's say a deed or something like that, where you could go get a copy of it. You have to go get a copy of it. You know, if it's something that that's one of your accounts that you can get just because it's somebody else has it, that's not good enough. If it's in your control, you've got to get it, right? Log into your account, download it, whatever. You've got to go get it. You can't just say, well, I checked my desk and it wasn't on my desk, so I'm not going to respond to it. What the fuck was this with this guy? Unlock. Do you really like locks? What is going on with that? Yes, I remember that particular. Yeah, but Chili can say it because Chili is also Jewish, so he gets to say stuff like that. So anyway, this is a garbage response, and I totally would have moved to compel further responses and a privilege log. Again, the same shit objection, the same only looking in very specific spots, and no privilege log. Well, it's a different objection. But it'd be nice if you said something like vague is the time, overbroad. Oh, here you go. Not limited time. There you go. Or identify the specific organization structure that's allegedly between each defendant. Yeah. That was a shit question. Confidential. Yeah. I remember something about that. All documents and things concerning disparagement. Vague and ambiguous. The request makes no attempt to identify plaintiff's associates. Yeah. No documents. So they aren't tracking you, Chili. Sorry, buddy. But see, notice how they're not saying things on here that they searched. What was it? The paper files of their unit. What would they? Paper files of their unit, their computer, and their work cell phones. All of a sudden, they're not limiting it on this. Isn't that weird? Isn't that weird? But Chili's too fucking stupid to make appropriate. We fucking get it, bro. We get it. He's too stupid to make a proper motion to compel further responses and to point out the issues with the responses that were made. Long story short, because it's getting cold, is the motion to compel discovery responses was denied. The court considered the motion along with the opposition because plaintiff's motion is based on defense alleged failure to provide any response to his request for production, but the object evidence shows responses were provided. The court issues this order before receiving plaintiff's reply. So the court notes defendants also provide plaintiff Dropbox link to documents and videos referenced, yada, yada. So Chili doesn't get to file a reply. The court is just done. There's nothing Chili could say at that point that would change the court's mind. When a party receives a request for production of documents propounded under Federal Rule of Civil Procedure 34, fails to respond to those requests, the propounding party may move for an order compelling production. The United States District Court for the District of Nevada, Local Rule number 26-6B, all motions to compel discovery must set forth in full the text of the discovery originally sought and any response to it. Defendants unequivocally demonstrate that they responded to all of plaintiff's RFPs. Plaintiff fails to acknowledge this fact and instead asserts he received no response from defendants except repeated reference to defendants' initial disclosures. In light of the objective evidence demonstrating defendants responded to plaintiff's RFPs, defendants' argument in favor of compelling responses to his RFPs lacked merit. Moreover, plaintiff's general assertion of no responses rather than identification of those responses by defendants he disputes as insufficient fails to satisfy plaintiff's Rule 37 burden. The party seeking to compel discovery responses must inform the court: 1, which discovery requests are subject of the motion to compel; 2, which of the responses are disputed; 3, why the party believes the response is deficient; 4, why any objections are not justified; and 5, why the information sought through discovery is relevant to the prosecution of this action. To the extent plaintiff is concerned defendants are in possession of additional documents responsive to his request, plaintiff must articulate something more than a suspicion to support his concern. Plaintiff's mere suspicion that additional documents exist is an insufficient basis to grant a motion to compel. Rather, the moving party must have a colorable belief for its basis that relevant responsive documents exist and are being improperly withheld. For each and all the reasons set forth above, it's hereby ordered the plaintiff's motion to compel discovery responses is denied. Now, the court was pretty specific, and this is the magistrate judge because this is a non-dispositive motion, but the court was pretty specific that you asked. Your motion is based on them not providing any discovery responses. The court is not sua sponte saying that the responses that the defendants gave are deficient. The court made it very clear. I'm only making my order based on your request, saying that there were no responses to discovery. So if Chili was smart, which he's not, he would file a new motion to compel. If there's time. Is there still time? California, you have like 45 days to file a motion to compel further answer. I don't see it. Maybe there is a similar rule in the FRCP, but I'm not going to take the time to look. Jose Castro. It's Decastro, bro. Come on, Gordon. You're the district judge. You should at least get a party's name right. Jose Decastro moves to strike the defendant's motion to dismiss, and the alternative, Decastro, asks for an additional 30 days to respond to the motion. I will not strike the motion to dismiss, but I will grant Decastro additional time to respond to it. I therefore order that Jose Decastro's motion is granted in part. Decastro's motion, or Decastro's response to the defendant's motion to dismiss, is due by January 26, 2024. So there you go. He got his. You almost always get additional time. Anyway, that's all I got for today. Thank you for watching, and have a wonderful weekend and a happy new year.